I have been a paralegal for 17 years. My name is Rhonda Baptiste. I work for a small civil litigation firm. 3 attorneys, myself, and a rotating law student or 2. We take what some larger firms call unimpressive cases: landlord-tenant disputes, employment claims, small contract breaches, cases where the money at stake is not enormous but the principle is significant to the people involved. The case I am going to describe went to trial in a municipal courtroom on a Tuesday in early September. It had taken 14 months to get there from the initial filing, which is not unusual. What was unusual was what happened to a witness on the stand during cross-examination. The plaintiff was a woman named Margaret Solis. She was 56, a property manager at a mid-size residential complex for 11 years. She had been terminated. The employer characterized it as a performance restructuring after she filed an internal complaint alleging that the regional director, a man named Brett, had approved a series of lease denial decisions that she believed were inconsistent with federal law. She had flagged the pattern in writing. 3 weeks later, she was informed her position was being reorganized away. The defense's position, stated plainly in their pre-trial brief, was that the termination was entirely unrelated to her complaint. The performance review that preceded it, they argued, had been in progress for 6 months before her complaint was ever filed. They had a paper trail. They had documentation. They had Marcus Webb, a regional HR coordinator who had processed the review, scheduled to testify that the review had been initiated on a specific date, February 14th. February 14th was 8 weeks before Margaret Solis filed her complaint. If the review predated the complaint, the retaliation claim had a serious problem. I had been preparing with our attorney, Gerald Kim, for 11 of those 14 months. I am not an attorney, but I am the person who reads every document twice and makes the timeline. And in August, 3 weeks before trial, I found something: the document metadata. The performance review document the defense intended to submit, the one dated February 14th, the one Marcus Webb was prepared to testify he had processed on that date, had a created on timestamp in the file properties that read March 31st, 6 days after Margaret Solis filed her complaint. I brought this to Gerald. He looked at it for 40 seconds. He said, "Are you certain?" I said. I ran it on 3 systems to verify. The document the defense was calling an 8-week prior review had been created 6 days after the complaint. Gerald filed a motion to compel production of the original file metadata. The defense objected on relevance grounds. Judge Holloway, who had been presiding over the pre-trial proceedings and would take the bench for the trial itself, read the motion in chambers and ruled the following afternoon. The metadata was relevant to authentication of the exhibit. Production ordered. They produced it. The metadata held. At trial, Gerald waited until the redirect portion of Marcus Webb's testimony. Webb had confirmed the February 14th date on direct, confidently. He had been a composed and professional witness. He did not appear to be lying, which I will note is a separate quality from not lying. On cross, Gerald established that Webb had processed the document himself, that he was familiar with the systems used, and that he understood document integrity was essential to HR record keeping. Then Gerald asked, "Is it possible that a document in the HR system could carry a creation date different from the date it was actually authored?" Webb said, "No. The system timestamps are automatic and cannot be altered." Gerald asked, "Are you certain?" Webb said, "Yes." Gerald had the metadata printout marked as Exhibit 19. He approached the witness with it. He asked Webb to identify the creation date shown in the printout. There was a pause. The kind of pause that courtrooms remember. Webb said he would need to look at it more closely. The date was not February 14th. Gerald asked, "Can you explain the discrepancy between the file's creation date and the date you've testified you processed this document?" I was sitting behind the bar at the plaintiff's table. I watched Marcus Webb's composure change. Not dramatically. It was a small thing. The way a person's face settles differently when the story they have been telling themselves is no longer available. He said he would need to consult with counsel. Judge Holloway said the witness was on the stand, and the question required an answer. Webb said, "I may have created the document later to formalize a review that had been conducted informally." Judge Holloway asked, from the bench, in her composed and precise voice, "Was the informal review documented anywhere?" Webb said, "Not in a formal record." Judge Holloway said, "Is there any written evidence that this review existed prior to March 31st? Webb said, "I would have to check." Judge Holloway said, "Counsel will stipulate that no such prior documentation has been produced." She looked at both tables. Defense counsel did not dispute it. The performance review that was supposed to predate Margaret Solis's complaint by 8 weeks had been created 6 days after she filed it. The defense did not rest that afternoon. They entered settlement discussions the following morning. I was not in the room when those discussions took place. I was at my desk updating the file. Gerald came out at 11:40 and said, "They've offered full back pay, 18 months, and a written release. She wants to take it." I said, "Does the amount reflect what she lost?" He said, "Close enough. She wants it finished." He went back in. The settlement was finalized at 2:15. I will tell you what I think about this, which I do not usually do. I think the thing that matters most in a case like this is not the verdict or the settlement or the number at the end. The thing that matters is the moment when the wrong thing is said clearly enough that it cannot be unsaid. When the document date is read aloud from the exhibit in a courtroom with a judge on the bench and both parties watching, and the witness cannot explain it, that moment is a kind of accounting. It does not fix everything, but it is specific. It is on the record. Margaret Solis had filed that complaint because she believed what she saw was wrong. 14 months later, in a courtroom, a document's creation date confirmed that she had been right to notice what she noticed. I updated the file. I made the timeline. That is my job, and I will keep doing it.